course you are.
Thank you very much. What's the temperature like now?
Tolerable.
Tolerable.
30 minutes.
Tolerable is all right, I think. Yeah.
My Lord, I was in the decision letter and picking up the further references where I say it's clear the inspector didn't err. Looked at 23 and 24. So it's on page 216 of the bundle. Paragraphs 25 and 26. The inspector again is faithfully recording the terms of the relevant paragraph of the PPG, and no indication there that he's treating them as some kind of straitjacket or in a mandatory way. Simply applying them as they stand. The next reference I rely on is paragraphs 27 in particular, where in the second sentence of paragraph 27 the inspector states, in this case, because of the inconsistency between the documents as to what is meant by reasonably available, I give lesser weight to the second section of policy CS3 than I did the newer and more up-to-date framework as interpreted by the PPG. So I make three short points on that. The first is that the last words, framework as interpreted by the PPG, it is indicating he understood that the PPG was intending to be an aid to interpretation as opposed to, or to a supplied interpretation, as opposed to overriding the framework or something of that sort. The second point is that the inspector expressly in that paragraph is giving weight to the up-to-date guidance in the PPG, indeed more weight to that guidance than CS3, and gives weight to that guidance in interpreting the framework. And I say that weighting exercise is clearly legitimate and can't be criticised. And my learned friend's suggestion that the inspector is somehow treating the PPG as a straitjacket is, in my submission, a misunderstanding of essentially the inspector simply giving the PPG weight. And the third point I make on this paragraph is that in response to my learned friend suggesting that the PPG could only be used as an aid to interpretation of the framework if it was published contemporaneously or nearly contemporaneously with the framework. And the points, it was put that the PPG in this case is some 10 years after the words originally appeared in the 2012 version of the framework. I say that approach is incorrect. It might be correct for, say, construing a contract where you're seeking to get at the intention of the parties at the date of drafting and agreeing the contract. But it doesn't read across to interpreting the framework, which is a document that the Secretary of State publishes and has not withdrawn. And it's clearly open to the Secretary of State to seek to clarify the content of that policy through the PPG without limitation as to time as to when he does so. And I also say it would significantly reduce the practical utility of the PPG if it couldn't do that. If it couldn't help out by providing clarification or explanation, for instance, on a term that there is causing difficulty in practice, PPG can step in and provide that. And Learned Friend's case is right, you'd have to reissue the framework or something of that sort, it would appear.
Yeah.
So that's paragraph 27, and then the two final references I rely on, again, all in aid of my submission. The inspector didn't misunderstand the intended role of the PPG. Firstly, in paragraph 35, towards the end of paragraph 35, the penultimate sentence, the inspector stated, however, the guidance provided in the PPG is a material consideration which I have taken into account in my decision. And that both correct as a matter of law, PPG is a material consideration, and also not indicating it was being given any greater role than that. And then the final reference I rely on is in paragraph 39, more of the same really, but to complete it, the last few words of paragraph 39, the inspector refers to the framework as informed by the PPG. And the language of being informed by the PPG, again, is certainly doesn't indicate any sort of straitjacketing role.
Yeah.
So that's the detailed look at the decision letter. Standing back then, as I say, given those findings, the inspector was entitled to find and give greater weight to the PPG and find them to be more consistent, to find the PPG to be more up to date and attribute weight to that, and find that the stricter tests in CS3 were not consistent with that more up-to-date approach in the PPG. As to those stricter tests, which the inspector refers to them, you've been taken to CS3 already, but I just briefly could go back to it. It's at page 31 of the supplemental finding. Sorry, page 8, no, yes. Yes,
Yeah.
quite right. Page 8 of the...
Page 8.
And at the CS3 on page 8, the end of CS3 contains the criteria which are an issue.
Yeah.
The second bullet point under number 2, the site can accommodate the requirements of the proposed development. Whereas in the PPG, it talks about the possibility, at least, of a series of sites accommodating the proposed development. So PPG suggesting that the approach in CS3 is there potentially too restrictive. And then
you concentrate on the singular word site.
Yes, which is how the inspector read it as well. I said it might be capable of more than one interpretation, but
and
the third bullet point, so the site either owned by applicant for sale at a fair market value or publicly owned land that's become surplus. Again, you don't find prescription in those terms in 728. Takes a...
That's the ownership.
Yes, indeed. Ownership or capable of acquiring ownership. And the third potential element of what a stricter approach is in the final 2 lines. Sites are excluded where they have a valid planning permission for development of a similar character and scale which is likely to be implemented. That's not something you find in 728. No. It may well be something that precludes a site being found to be reasonably available, but it's not spelt out, at least in 728.
Yeah.
So that's the second part of CS3. I also can I just the first limb of CS3 is also relevant, which is it's the second paragraph beginning development in zones 2 or 3 at the top of the page.
Yeah.
And as to adopt the statements of the court to some extent, it refers to the sequential test as set out in the National Planning Policy Framework. And as my Lord said, it is, in my submission, legitimate for a policy to incorporate national policy in that way, such that if national policy either changes or there is a changed understanding of national policy, that enables the development plan policy essentially to keep pace with national policy and stay up to date because it has incorporated the national policy within it. So the NPPF is there embedded in CS3, an entirely legitimate and understandable approach. And that part of the policy, the inspector said, well, that of course is up to date because it stays up to date with the framework. It's the second part of CS3, the bullet points which are more restrictive, which he found inconsistent. And I say no error in that approach to CS3, no misinterpretation. So putting all that together, I say the inspector was entitled to find the second part of CS3 inconsistent with the framework as now understood with the assistance of the PPG. The inspector was entitled to find that the development was not in accordance with the first part of CS3 and not in accordance with the framework as understood by the more recent guidance, and then was entitled to find that the development was in conflict both with the development plan and the framework as a result.
Right.
And for those reasons, Lord, I say the inspector committed no error of law. And the only other point, which essentially concludes my submission's bar one short point, which is I was dealing with some of the case law earlier, and I made my sort of overarching points about the first instance cases relied on by the learned friend. Been to Solo Retail, then just wanted to make a point about Menston. Take that up again. It starts at page 120 of the authorities bundle. And the passage of relevance into it's page 140, paragraph 41. And I'd say two things about paragraph 41. Mr. Justice Dove there said, the paragraph of the PPG to which the claimant makes reference is first obviously subservient to the policy for which it provides practice guidance. Just pausing there, I say that is in terms dealing an exercise in interpretation of the specific paragraph of the PPG in question. It's not couched as a broader remark on the respective roles of the NPPF and PPG. And secondly, even if it's taken in a broader sense that the PPG generally would be subservient to the NPPF, I say paragraph 728, as understood by the inspector, is consistent with that because 728 is in terms providing an explanation of what reasonably available means in the framework. And in doing so, it is subservient. It's taking a phrase from the framework, explaining what it means. It's performing a subservient role, sitting underneath the framework.
So you say paragraph, you could apply that language to paragraph 0728?
Yes, I do say that. I haven't been to the other two cases, White Waltham and Bramley Solar. I say that they're of a piece, essentially exercises in interpreting the PPG in question, and don't contradict with the approach taken to the PPG by the inspector in our case.
Right.
And my Lord, unless I can say further, those are my submissions.
John? No. Thank you very much, Mr. Flanagan. Thank you. Well done.
My Lords, my Lady, there may not be a huge amount between us now in the light of how my learned friend's submissions were put, certainly before London. Doesn't submit that any of the cases I've taken you to were wrongly decided. He seeks to find their facts. You have my submissions on that already. He says solo retail is a case about the interpretation of the PPG. I'll come on to why I say absolutely it is. The proper, how it is to be interpreted in the sense of where in the hierarchy does it sit. He repeats the point made by the judge below regarding the source of the power being the same as the MPPF and the PPG, and says that the Secretary of State could theoretically amend the framework via the PPG, but he acknowledges that this is not how the PPG is currently intended to or does operate, so that doesn't really matter. He says it's a supporting suite of guidance. We agree. So the source of the PowerPoint and the case law to which that relates is with respect to distraction. It appears to be common ground, and in any event, I invite you to conclude that the proper interpretation in the Tesco and Dundee sense of how the power has been exercised via the PPG is as set out by Mr. Justice Dove, Mrs. Justice Leven and Mrs. Justice Lang, i.e. not a binding code and subservient to the primary document, which is the PPG. And that's why I say, yes, so there was a case about interpretation. Where in the hierarchy does the PPG sit? How is it to be construed? Even if there are superficially mandatory words, is it actually binding code for the purpose of compliance of the framework? Now, treating 7028 as providing a set of binding criteria for the purpose of 162 would stray beyond that agreed subservient role. It would be a binding code when it now appears to be accepted by the Secretary of State that the case law saying it can't be a binding code is correct. But in fact, Mr. Flanagan conceded before lunchtime, I think, I'll be correct or wrong, I think the first time in these proceedings, that 7028 is not exhaustive, and of course it's not exhaustive. That's how it seems the Secretary of State seeks to square his case with the apparently agreed legal principles that the PPG cannot be a binding code, and, at least for now, is not intended to and does not amend the framework. And that basis of which he says, essentially, it's analogous on his own case, if it's a non-exhaustive, the purposes of the sequential assessment. 7028 is non-exhaustive. It's analogous to the retail assessment checklist in solo retail, and analogous to the noise assessment guidance in White Waltham. Both of those were held to be non-exhaustive. And that's why it was, although they use superficially language that, as I said, has the flavour of obligation, the assertion by the claimants in those cases that they were binding and qualified the framework was held to be excessively legalistic. This is in a sense the converse, because it's the inspector who did what the judicial review claimants in those two cases did. Now, that's a fatal concession on the facts of the cases I'll come to when one construes the decision letter. But to assist the court, I suggest this may be, this non-exhaustive exhaustive point may be the principal dividing line as between what the framework and the PPG, as currently held out by the government, supporting suite, can do in relation to definition. So on the one hand, the framework glossary, Mr. Flanagan and I agreed you may be assisted by seeing the framework glossary. So in the material we provide you tomorrow, we'll provide you with that, appreciating you're familiar with it. But the framework glossary can and invariably does provide exhaustive binding definitions, and you'll see that when you get it. The PPG can, consistently with the principles I've invited the court to adopt, provide non-exhaustive guidance on the meaning of terms used. That's elucidation. What it can't do is provide an exhaustive definition of terms used in the framework, for that is to become the binding code, which the cases, now not contested by my learned friends, say it can't be. So then, in my submission, if you're with me so far on that, then the question then becomes, on a fair reading of the decision letter, applying the principles one applies to readings of decision letters, did the inspector treat 7028 as non-exhaustive, as we are both now agreed he can only lawfully have treated it, or did he treat it as exhaustive, in which case it would seem to be agreed he's made an error of law? And without repeating, I'm going to give you a few highlights, but without repeating what I said before, I submit that reading it fairly and looking at the substance, he did treat it as exhaustive. I would suggest, actually, though it's not actually really a head count of words used, one looks at the substance, which I'll do. It's Mr. Flanagan who's cherry-picking the words informed and clarified. And actually, when one looks at it, the language of defined, etc., is much more pervading and reflects the substance. And I'll explain why that is, fine without repeating myself, but the effect, as the inspector saw it, of PPG 728 was that the second part of CS3, the for the purpose of the sequential test bits, which were previously a legitimate local application of 162, that was now inconsistent with his language DL23, I think from memory. Just check, it might be 21. Anyway, now inconsistent with paragraph 162. Why was it now inconsistent with 162? It was inconsistent with 162 because the considerations CS3 referred to were, to use Mr. Flanagan's language when defending this part analysis, not something you find in 7028, his words. Well, that is to treat 7028 as exhaustive. Not something you find. That's how my learned friend sought to defend that language. That is the language of exhaustiveness, not non-exhaustiveness. And it's agreed now that it's a non-exhaustive guidance. And the way to illustrate that, or a way to illustrate that, is if I can ask the court to turn back to the decision letter and go, I rather skirted over page 214, the section of the decision which explains why looking at CS3 standalone, which but for the framework was consistent, the whole range of considerations that the inspector took into account between 10 and 22, applying the CS3 points that Mr. Flanagan's just taken you back to a moment ago. And those considerations inform the planning judgment that there is compliance with CS3 on the face of it, which was, up until the framework, consistent with the framework. And then what led to the different position? We'll go forward, if you wouldn't mind, to page 218. 37 and 38. The alternative sites put forward by the council, whilst they did satisfy the considerations referred to in CS, they didn't satisfy, forgive me, the other way around, they didn't satisfy the considerations in CS3 and were therefore, for CS3 purposes and NPPF 162 unvarnished purposes, not reasonably available. They did meet the definition of the framework because of the PPG, and only because of the PPG. So when you compare the latter part of the decision letter to the first part, It is precisely because the considerations listed in the second part of CS3 were, to repeat my learned friends, not something you find in 7028. It is precisely and only because of that that the inspector considered that the framework test was failed and there was the inconsistency between CS3, which set out considerations for the purposes of the sequential test, and 7028, where those were not things you find in. So in substance, reading the decision fairly, it's not just about how many times do you say definition compared to how many times do you say clarified. In substance, analytically, the only intellectually honest way of reading this decision is the inspector treated 7028 as exhaustive, and it is now conceded by the Secretary of State that it is not. And that, my lords, with respect, ought to be the end of the matter. It may be, as my Lord Sir Keith Limbom said, it may well be that DL24 replicated the question posed by 7028, what does reasonably available mean, but to attach decisive significance to the way that the language is phrased in the PPG is to make the same mistake as the claimants did in Solo Retail with the checklist, and in White Waltham with the noise guidance, to treat superficially mandatory language as properly interpreted, having regard to the BPG status in the hierarchy as a binding code, which it isn't. Superficially mandatory, but in substance non-exhaustive. Alconbury, given the concession that the PPG doesn't, in fact, amend the framework or set guidance, is probably a distraction, but just to be clear, for the avoidance of doubt, Alconbury predates the framework and the practice guidance, so clearly couldn't possibly have had the relationship issue that's before this court in mind. But also, there's a danger of getting confused by the term guidance. My Lord, you will remember that national policy, before they were PPSs, they were ironically PPGs, planning policy guidance.
They were planning policy guidance.
Before my time, but not before, with respect to your time.
Yeah.
And so actually the term guidance policy was used interchangeably.
There were circulars once.
There were, yes, even before your time.
No,
or not.
Well, slightly.
But you get the point. So guidance and policy was used interchangeably in that context, whereas following the framework and the guidance, there's been a sort of fork in the road in terms of how that terminology has been used. So Alconbury is, and Hopkins doesn't determine the relationship point either. It wasn't before the court. But I say, like the concessions made, it may well be that the court doesn't need to go there anyway. One last point, I think, with DL27, just to be clear, my learned friend characterised a few moments ago the weight point as being the weight between PPG versus CS3 in considering accordance with the framework. That mischaracterised what the weighing exercise was doing. What the inspector is doing is weighing on the one hand CS3, which because of the PPG he says is now inconsistent with the framework, with on the other hand the framework as informed or interpreted, as he says there, by the PPG. So the balance of considerations isn't quite as my learned friend put it. That may or may not be useful, because in my submission, one looks at the substance, it's clear what he decided anyway. I need to correct one thing I said earlier when I said that or clarify, which is that I said the consultation text of the current framework isn't proposing any changes to 162. That's correct as far as it goes. Ms. Bono has very helpfully pointed out one of the questions in the consultation, question 80, for yes, there are that many. That's the degree of care that's done in relation to revision of the framework. Question 80 does essentially say, I'm simplifying, but should we change flood risk policy?
Oh.
So you should probably see that.
Sorry,
I'm over. So the exact formulation, I have a post-it note. So you see it when we provide it to you. But essentially, it is: do you think we should change flood risk? Are there any problems in relation to flood risk policy?
Oh, I see.
So there's no changes proposed, but it would be within scope and for them to provide changes in the final version, because the prospect of it has been consulted upon. It wouldn't require reconsultation.
Okay. Fine. Well, I think we do need to see chapter and verse on that. Then.
Yes, we already work is in train to provide that to you.
Thank you very much for that.
Unless consist the court any further, those are our submissions. Thank you.
Thank you very much.
Thank you.
Thank you. Well, thank you both. Thank you all three, if I may say so, and those who have assisted you with the preparation of submissions, both written and oral. Thank you for the very clear and concise way in which those submissions have been delivered to us, for which we are grateful. Thank you. You've given us enough to think about that we will reserve our judgments. They will be provided in draft in due course in the normal way for typographical and any minor factual corrections at that stage. An order to be agreed in draft. Any submissions relating to matters not agreed in that draft order to be presented to us at the same time, please. There will be the usual embargo arrangements, which must, as always, be heeded, for there will be consequences if they are not. Thank you very much.